Welcome to Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien. Kyle is off today celebrating some graduations this weekend, and Patrick is sitting in as a guest co host. This is episode 7, State of Missouri versus Marcellus Williams, part 3. We'll wrap up our review of the case against Williams and talk about the 2024 efforts of the St. Louis County Prosecutor's Office to vacate Williams's murder conviction and the office's opposition to his execution on September 24th, 2024. We'll also talk about the DNA results that were falsely held out to exclude Williams as the perpetrator of Felicia Gale's murder. First, I want to take a moment to honor Carol Stites, who passed away on May 12, 2026. Miss Stites was an amazing woman who relied on her unshakable faith to overcome adversity in her life. She was stronger than she believed herself to be. During the last 6 years or a little longer, Miss Stites has been an advocate for her youngest daughter, Stacy, who was murdered in 1996. As she'd always done, Miss Carol relied on her faith to cope, often telling others that she gave it to God, and that helped her. In addition to Stacy, she was also preceded in death by her second husband, Herbert Stites Jr., and her son, Clifford Baker. She's survived by her daughters, Brenda, Crystal, and Deborah, and several grandchildren and great-grandchildren. And welcome, Patrick. I think this is your first time sitting in for Kyle.
This is, my first podcast, but I really appreciate it.
Oh, no, I'm so glad you could join me.
Hey, can I start just by saying that I'm honored to be here and Based in Fact with you, and thanks to Kyle for letting me sub for him. And I should tell people that I'm a longtime fan of yours and your podcast and seeing you on Twitter. And here's why. Sometimes in our country, when someone's convicted, then they lose their direct appeal, they lose their post-conviction relief, they're found guilty after a full trial with all the safeguards and all the multiple layers of review. Well, they might actually be guilty. And most other true crime podcasts that I've listened to seem to cover the death row cases like it's basically advocacy disguised as journalism. And then, of course, there's the innocence fraud industry that makes money by falsely pretending that, death row is populated by nothing other than misunderstood, unlucky, innocent people. And then you have the general public. They read the headlines and the stilted coverage that I think too often romanticizes the murderer and steps on the memory of the victims. But I think what you do, and you and Kyle do, is you sift through the trial evidence and the procedural history and lay everything bare out on the table. So that's why I look forward to always speaking with you and listening to your podcast.
Thank you so much. I appreciate that. Sometimes I wonder, whether this has any impact, and it's really is great to hear that it does.
I think
So thank you.
besides it's setting up a testament to some of these things that happen, and I think it's great that you put so much effort into it, and really kind of leave nothing, no stone unturned, and very matter of fact. So yeah, thank you for what you
Thank
do.
you. All right. Well, let's get started. We're going to kind of go over a little bit of a review before we get into the meat of part 3. Of course, we start with the victim, Felicia Ann Lisha Gale Pecos. She was born February 6, 1956 in Rockford, Winnebago County, Illinois. Her parents were George Wally Gale and Veronica Bunky Bunk Gale, who passed away in 2021. She was the second of 8 children. Brothers and sisters were William, Sanford, Andrew, Sydney, also called Beth, Samuel, Emily, and Christopher. She was a graduate of Guilford High School, and she spoke at the commencement, and also a graduate of the University of Illinois, where she majored in journalism. She worked with the Illinois State Journal in Springfield, Illinois, the Hammond Times in Hammond, Indiana, the St. Louis Post-Dispatch in St. Louis. She did the police beat. She did that from 1981 to 1992, and then she was burnt out, I think. From what I understand of her personality, she was, light and love, and the darkness was getting to her, I think.
Hmm.
And she also served as a mentor tutor to disadvantaged children in St. Louis inner city schools. She was married to Dr. Daniel Pegas on September 21st, 1979. They were high school sweethearts, and her injury cause of death were multiple stab wounds. And then we have the perpetrator. It was Marcellus Scott Williams Sr. He was born December 30th, 1968 in South Bend, St. Joseph County, Indiana. His parents were Rayford Daniels and Ella Louise Williams. He had three brothers. He dropped out of 10th grade during the second semester. He has a child, Marcellus Scott Williams Jr. He may also have other children or another daughter, at least one other child, but the only one who's been identified through the press has been his son, Marcellus Jr. Emotional mental conditions are oppositional defiant disorder, depression, and post traumatic stress disorder, which were diagnosed post conviction. Of course, he had 7 juvenile arrests and had been committed to the Division of Youth Services as a juvenile. He had 16 adult convictions, including 2 armed robberies, in addition to his armed robbery murder conviction for the murder of Felicia Gale. He was incarcerated for 7 years from 1990 to 1997. His disciplinary history included 100 infractions, including verbal and physical altercations with inmates and corrections officers. And he threatened to kill a corrections officer in 1999 at the St. Louis City Workhouse during an escape attempt. And of course, his victim was Felicia Ann Gale Pegas, who was 42.
I was going to say, Lisa, that I was looking at your notes, and at first I saw the crimes in 1991 to 2000. I thought he kept out of trouble, but he was incarcerated.
Correct.
Okay, so
correct. And as soon as he was out, as soon as he got out, he was back at it.
Robbery and
yeah, armed robbery. I think it was like there was an armed robbery of a Burger King, and then there was an armed robbery at a donut shop. And I think it was the Burger King armed robbery that got him. He got caught right then. So, so the crime occurred on August 11th, 1998. The victim was Felicia Ann Gale Pegas, who was also known as Lisha. She was 42. On the morning of August 11th, Lisha finished her daily 2-mile run and, after a chat with her neighbors, returned to the home she shared with her husband to shower and change into her favorite long purple shirt. Williams left his grandfather's Buick LeSabre at a bus stop in St. Louis and rode the bus to University City, an upscale St. Louis neighborhood, where he chose Lisha and Daniel's house because a tree partially obstructed the front door of the house. When no one answered Williams's knock at the front door, he broke the glass in the door, reached inside to unlock the door, and entered the house. It's also believed that he was wearing gloves. He heard water running on the second floor. Williams could have grabbed valuables and gotten out of the house, but he didn't. Instead, he went downstairs to the kitchen, armed himself with a butcher knife, and laid in wait for his victim. Lisha finished her shower and put on her t-shirt, then went downstairs, and it's some of the accounts, she had probably heard him and called out, and that's what led him to go get the knife and wait for her. When she encountered Williams, he attacked her with the knife. She was stabbed 43 times. 16 of those wounds were fatal, and she had wounds in her head, back, thigh, and neck. She also had defensive wounds on her hands and arms. When Williams was done, he left the butcher knife in her neck. After he killed Lisha, he grabbed a jacket to cover his bloody shirt, stole Lisha's purse and her husband's laptop and case, and returned to the bus stop, riding the bus back to his grandfather's car. When he picked up his girlfriend, Laura Sorrow, she saw Williams's bloody shirt and scratches on his neck. Williams told her he'd been in a fight. Later that day, she watched as Williams put his bloody clothes in his backpack and threw it down a storm drain. Asaro also saw a laptop computer in the car. A day or two after the murder, Williams sold the laptop to Glenn Roberts. Shortly after that, Asaro went to retrieve clothes from the trunk, only to be pushed away by Williams, who didn't want her looking in the trunk. That didn't work, and Asaro found Licia's purse. When she looked inside and found Licia's Missouri ID and a black coin purse, Asaro demanded to know why Williams had another woman's purse. It was then that Williams confessed to Asaro, telling her he'd broken into the house, found the butcher knife, and waited for Alicia to get out of the shower. He then told Asaro that he'd stabbed Alicia in the arm, then covered her mouth, stabbing her in the neck and twisting the knife. After confessing, Williams grabbed Asaro around the throat and threatened to kill her, her children, and her mother if she told anyone about his confession. On August 31st, 1998, Williams was arrested after a robbery at a donut shop. He was incarcerated at St. Louis City Workhouse and facing charges for that crime. In April 1999, Henry Cole was assigned to Williams's room. One evening in May, there was a news report about Licia's murder that included information about a reward of $10,000 being offered by her family for information leading to the arrest and conviction of her killer. It was shortly after that report aired that Williams admitted that he'd committed the murder. Over the next several weeks, Cole and Williams had several conversations about the murder, and Williams confessed. As he'd done with Asaro, Williams provided details about how he broke into the house and his attack on Licia, which included information that had never been released to the public. And it's important to note, Cole did not go to the authorities at the workhouse and say, hey, this guy's confessing to me. What can I get?
Yeah.
He just continued talking to Williams about this. It was after Cole was released in June that he went immediately to the University City Police, where he was interviewed on June 4th, 1999. He reported Williams' statements and directed police to Asaro, who had not yet come forward. She was interviewed initially and didn't know anything, but when she was interviewed on November 17th, 1999 by University City Police, she then told them about Williams' confessions, providing information that could have only been known by the killer. And both Cole and Asaro, what they told police had not been released.
But Asaro probably wouldn't have said anything, do you think, if Cole hadn't?
Well, she was afraid, genuinely afraid of Williams.
Right. Yeah.
And I
Yeah.
believe even after he was arrested in August, when police initially talked to her, she knew nothing
Yeah.
in September. And she had been arrested. So there's apparently an interview where she did say she had information about the murder, but then when it came down to it, she didn't know anything.
Clammed up. Yeah. Well,
But that was probably fear of Williams as well.
yeah. If someone tells you that they stabbed someone mercilessly in the neck, then you might believe them when they said they're going to hurt you if you say anything.
And the following day, police searched Williams's grandfather's Buick LeSabre and found a St. Louis Post-Dispatch ruler and calculator that had belonged to Licia. They were also able to track down Daniel's laptop computer, and that had been sold to Roberts by Williams, and they were able to identify it as the one stolen from Licia's home after her murder. So they were able to link it to Daniel Picus.
Mm-hmm.
And they also secured Roberts's cooperation. And in working on notes and looking at stories around his execution, they made it sound like it was just a generic laptop computer that they never linked to anybody. But that's not true. They were able to conclusively prove that it belonged to Daniel Picus.
Something tells me that he wasn't really good at bleaching out the information on the laptop.
He may not have even known or cared.
Right.
And he did try. He did. I think he had like a contingency plan if he did get caught. He told Roberts that he was selling the computer for his girlfriend.
All right. Gonna
So
get her in trouble.
planting a story that gets him out of trouble.
Right.
So he was convicted on June 15th, 2001, after a trial of burglary first degree, murder first degree, armed criminal action, robbery, first degree, and armed criminal action because he was armed during both the burglary and the robbery. That's Missouri for dangerous weapon.
Right.
Um, and uh, interestingly enough, some people might wonder he's charged with burglary. The burglary occurred when he entered the house.
Right.
The robbery occurred when he took
When
uh,
he,
property from the house.
oh, okay. Walking into a place that you're not allowed to be in is
Correct.
burglary.
Is
Right.
burglary. Yes. And I believe you don't have to take anything. Just
Right. Just
entering without an invitation, without permission
that's
is
not
burglary.
trespassing. That's burglary. I guess.
Well, and I think different states are going to call it different things.
Yeah.
And burglary may be if you enter with the intent to take something, even though you don't actually take anything.
Right. Yeah. Yeah. I guess
So,
trespass might be reserved for like if you're on someone's front lawn, but if
right.
you opened up a door and walk in,
And
then there's burglar.
and I believe in most cases, trespassing, you have to be told not to go to the place.
Oh, right. Yeah.
So that's why, like, if you've been told by your ex-mother-in-law to get out of her
Right.
house and stay out of her house,
Right.
and you go back and go in, it's trespassing. But if you've never been
Mm.
told to stay out or stay out, it would be burglary.
Right.
So, but again, different states are going to define it in different ways. His judgment of conviction was entered on June 15, 2001. The jury then deliberated again after punishment phase. And on June 19th, 2001, they agreed to sentence Marcellus Williams to death. He was formally sentenced on August 27, 2001. He received 30 years on count 1 burglary, death on count 2 murder, 30 years on count 3 robbery, life on count or 30 years on let's see, count 3. Yeah, 30 years on the armed criminal action for the burglary,
Hmm.
life on the robbery, and 30 years on the armed criminal action. And I believed those sentences were consecutive with one of the earlier convictions for the either the Burger King or the donut shop.
Hmm.
So he was if he hadn't been sentenced to death, he probably would have never walked out of prison
So it would be
because
90 years.
yeah.
Yeah.
Well, he would have had to do 30 years on he had 30 years consecutive sentences in the prior burglary. So these counts would not begin to run until he served
Oh,
that full
the
sentence.
Burger King. Okay. Yeah.
And I think it was the Burger King because that involved a robbery where several employees were present.
So 120 years if he didn't wasn't given death.
Probably. Now these 30 years might have been consecutive concurrent to one another.
Concurrent. Right.
Yeah. But like I said, they wouldn't begin to count until the other 30 years had been completed. He filed his direct appeal, which was his conviction and sentence were affirmed on January 14th, 2003. And then the court modified their opinion on June 6, 2003. But there's not I don't have the one they issued in January and then the one they issued in June to compare to know what was different. But they did do some kind of some modification of their opinion. An order was entered on March 24, 2003, staying Williams's execution until further court order. Because in Missouri, they set an execution date. I don't know what that date was, but they stayed it while he went through state post conviction, which he did. In May 14th, 2004, relief was denied. That decision was affirmed on June 21st, 2005. He filed a writ of habeas corpus, which was denied on January 31st, 2017, dealing with post-conviction DNA testing. On August 15th, 2017, second writ of habeas corpus was denied.
Is this the death penalty? Usually, it's an automatic appeal, right?
Yes, the direct appeal. Yes, the direct appeal is of right.
But that's not these are
State post
pre-appeal.
conviction, yeah, and he
Okay,
filed. He filed with the. He filed writs of habeas corpus in state court with the Missouri Supreme Court.
right.
And he filed one in 2015 dealing with post conviction DNA testing. That was denied in 2017. He filed a second one in 2017, almost identical, I believe, dealing with post conviction DNA testing. That was also denied on August 15th, 2017. He filed his federal habeas corpus claims. He had a motion to conduct further DNA testing to authorize discovery and hold an evidentiary hearing that were denied on March 30th, 2007. His petition for writ of habeas corpus in federal court was granted in part and denied in part on March 26, 2010. Basically, the court granted his claims related to his death sentence and vacated his death sentence, but denied as to his underlying criminal conviction. On June 16, 2010, the state's motion to alter or amend judgment was denied. The case then went to the Eighth Circuit Court of Appeal. Williams's request for a certificate of appealability in his separate appeal was denied on January 15, 2010. On September 18, 2012, the Eighth Circuit Court of Appeal reversed and remanded the habeas corpus claims on the state's appeal to the district court with orders to dismiss the petition and enter judgment for respondent. So they found that the grounds for reversal or vacating the death sentence were not proper, and they reinstated his death sentence. On December 19th, 2012, the district court, following the ruling of the Eighth Circuit, issued an order and judgment dismissing Williams' writ of habeas corpus with prejudice and entering judgment in favor of the respondent. Williams filed a motion for relief from judgment, which was denied on August 15, 2017, and the Eighth Circuit Court of Appeals affirmed that on August 18th, 2017. Williams also filed several petitions for writs of certiorari to the United States Supreme Court. They were all denied in 2003, 2011, 2013, and he had 3 denied in 2017. And they were challenging various state and or federal court decisions, which I think we went through in episodes 1 and or 2.
Yeah, correct. Yeah.
He also filed a 42 USC 1983 claim in 2014, which was dismissed on January 14, 2015. And there was an order that the appeal would not be taken in good faith, so that was not appealed. He had several dates of execution. He had March 4th, 2003. He had June 6, 2003, which was set on March 4th and stayed on March 24th. He had January 28, 2015, which was stayed on January 22nd, 2015, and then August 22nd, 2017, which was stayed by the governor on August 22nd, 2017. That was by Executive Order 17-20. And then on June 29, 2023, Governor Michael L. Parson dissolved the Executive Order 17-20, clearing the way for Williams to get a new execution date. So I have some new information that I found while I was working on my notes for this episode. And these are the forensic reports, both pre-trial and during post-conviction. So I'm just going to go through all the DNA results that we have in this case. There was a DNA profile from a swab from Felicia that was consistent with Daniel Picus, and so he could not be excluded as the source of the genetic material in that sample, just meaning Williams didn't rape her.
Right.
Um, and then the non-sperm fraction was consistent with Felicia's DNA. Then in 2001 testing, they found insufficient DNA isolated from 5 hair samples to yield reportable results. They had a reference sample from Williams that they didn't report, but they could report. And then they also had DNA from 2 hairs and reference samples from Felicia and Daniel, but they found insufficient sequencing information obtained from the 2 hairs for comparison purposes. So the hairs don't identify anybody.
Right.
And they had parties in their house. This was from a carpet that had never been professionally or like steam cleaned or cleaned.
And this is
They'd
back
lived
in
in the house for several
2001,
years. Yeah, yeah,
back when DNA wasn't as reliable as it is now, or
right.
searching for DNA isn't
What
as
they could
reliable.
find was sometimes limited, and they needed more material than they
Right.
often had. Then further testing in 2001, they couldn't make an association to Williams's shoes based on examination of lifts and photographs of footprints at the crime scene. However, I question whether they had the shoes Williams was actually wearing. Because if those shoes were in the backpack that he threw in the storm drain
With his
that
bloody
they
shirt.
never found, then they didn't have the actual shoes he was wearing.
Mm-hmm.
So
Probably got blood in the shoes.
probably so. Then they examined additional hairs from the rug and duffel bag that were not microscopically similar to Lisha or Dan. They had a blue fiber that was not similar to the blue shirt and hooded short sleeve shirt from Williams, but again, he threw the clothes he was wearing away in a storm drain that they never found.
And this is an
So,
assumption, but probably the gloves too, because there's
mhm,
nothing, right? There's
right.
no fingerprints, no.
And then there were additional hairs and hair fragments that were not grossly associated with Linda or Dan Picus. And in forensics, DNA, fingerprints, hair, for the most part, if you don't have a reference sample, that evidence is not going to tell you anything.
Right.
You're just going to have an unknown DNA profile. But, it could be an unknown DNA profile unrelated to the murder because it's from her sister
Sure.
in law,
Yeah.
or, like say it's her sister in law who's not related to her, you know. So, and then they had genetic profile obtained from fingernail clippings from Lisha's right hand, 2 samples, and left hand, 1 sample, are consistent with a single source DNA originating from a female. The profile from all 3 items is indistinguishable from Lisha's DNA. So you hear about the fingernail clippings that they wanted to test, but they already knew that that belonged to Lisha, or
Right.
it didn't exclude Lisha. The genetic profile obtained from 4 blood-stained cuttings from the T-shirt, a T-shirt belonging to Pierre Baker contained a mixture of at least 2 individuals. A minor male component was reflected within the mixture, and Baker could not be excluded as a possible contributor to that genetic profile. So they had a T-shirt from another suspect, but it wasn't Lisha's blood. And they found that Lisha's profile was not consistent with that of the overall major or minor contributor profiles obtained from the cuttings, even though she shares common alleles detected within the mixture. and then they examined 12 hairs, but none were similar in gross appearance to Williams. In 2016, Bode Cellmark issued a report on April 8th, which examined 4 human hairs that were not suitable for DNA analysis, but may be suitable for mtDNA, mitochondrial DNA. Excuse me. They found no Y STR profiles from the 3 fingernail clippings from Felicia, which means there's no male DNA detectable. They did find a partial YSTR profile from the knife, consistent with a mixture of at least 2 individuals, due to the possibility of allelic dropout. No conclusions can be made on this partial mixture profile. The mitochondrial DNA data obtained from 1 hair was not reportable. The mitochondrial DNA profile obtained from 2 hairs was consistent with Felicia's mitochondrial DNA profile, and she could not be excluded. And then mitochondrial DNA profile from another hair was consistent with Dan's mitochondrial DNA profile, so he could not be excluded. Then in August 12th, 2016, they did additional YSTR testing, and the partial profile obtained from the knife handle was consistent with a mixture of at least 2 individuals. Due to the possibility of allelic dropout, no conclusions can be made on this partial mixture profile. And then in a deposition given by the analyst for the DNA for Bodie, I don't know how they pronounce their name, November 29th, 2016. Basically, I'm not going to go through all the results because it was a lot, but basically, Williams could not really be excluded based on their criteria, and he did have some alleles in the mixture. There were some alleles in the mixture that Williams shared. So,
but it wasn't enough to be undoubtedly him.
They couldn't exclude him, but they couldn't include him.
Right.
Or they couldn't include him and they also couldn't exclude him.
Right.
Because they just didn't have sufficient data. Now, Williams, of course, goes out and he gets 3 experts who all say in 2016, 2017, and 2018 that they can absolutely positively exclude Williams as a contributor to the mixed profile on the knife.
Right.
Which is not, it's not, if he wore gloves, of course he's not going to leave any DNA behind.
Right.
So.
And it could be the husband and wife who have DNA on there.
And it could be a guest who came in the house and used the knife. It could be, and we'll see a little bit later.
Okay.
What happened, but I decided not to spoil anything for anybody.
We'll build to it.
Yeah. So, I put these together because this all happened before the timeline in this episode. So, but I left the new stuff for later.
Mm-hmm.
All right, so we moved to the state seeking another execution date. They filed a renewed motion to set execution on June 30th, 2023. The state granted Williams an extension of time to respond to that motion, and actually granted 2 extensions of time on July 21st and August 30th. Then Williams filed his suggestion in opposition to the state's renewed motion to set execution date on September 14th, 2023. And basically, he argued that he was pursuing a declaratory judgment action challenging the governor's vacating the earlier executive order and dissolving the board appointed by that order to examine Williams' conviction. The state filed a reply in support. On January 26, 2024, the prosecutor's office, now we're going to refer to the state is going to be the AG. The prosecutor's office is going to be the prosecutor. Prosecutor Wesley Bell jumped on the Marcellus Williams bandwagon and decided that he would use his office to get Williams a new trial, and then he would then not prosecute Williams.
So, Lisa, let me ask you:
kind of like Adnan Syed. The fix was in.
So the previous governor was kind of like on his side, trying to delay the execution and set up a board to, and then the new governor seemed to like want a fast track.
Well, not exactly.
No.
The governor, based on what was presented to him in clemency and the arguments about this allegedly exculpatory DNA evidence, which really wasn't exculpatory even then,
right?
And that was the basis of one of Williams's writs of habeas corpus in 2015, and the Supreme Court of Missouri found that wasn't exculpatory. The governor did grant a stay, and he set up the board of review. Then Governor Parsons comes in. Greitens was out within 6 months.
Mm-hmm.
He got into serious trouble.
Right.
And resigned. And Parson came in. 5 years later, the board has not done anything. They have not issued a report. They have not sent any findings to the governor. They haven't done anything. And so Governor Parson thought, well, maybe there's nothing there's nothing for them to do.
Right.
And so he said, okay, well, let's get this show on the road. And that may have also been his way of getting them to do something, which they never really did. And so he dissolved them.
Yeah.
But we'll get into the declaratory. The declaratory judgment comes as well.
Is it strange that board was set up just for him? I mean, they weren't deciding any other death penalties. Huh? Was it just...
Well, there was a new statute that basically the governor could have picked any case, any claim that was before him for clemency.
Oh, you're right.
It wasn't, it happened to be Williams, but I don't think it was. And I think Greitens' intentions were good.
Mm-hmm.
I don't think he was up to anything nefarious. But again, he thought that the claims presented to him on clemency had merit.
Right.
And bore the need for investigation.
All right. So they were neutral. The new governor wasn't out to see the execution sped up. He's just realistically saying, if you're not going to do anything,
correct,
we're not going to have a board. Yeah. Okay.
Correct. Basically. And like I said, this one, I referred to it as shenanigans because my phone kept replacing the word I really wanted to use. Which I won't use right now because I'm going to try not to do that so often on this show. Try to clean up my language a bit. But you've heard me before, you can probably imagine.
Yeah.
But so we're going to be going back and forth in time because there were so many balls in the air that it was easier to just deal with each one through its life than to try to deal with it in a single timeline. So the notice of proceedings is filed. That's basically where Bell's filed a motion to vacate Williams's conviction, a la Adnan Syed. Luckily, the judge wasn't in on it.
Right.
So then he filed a motion for leave to file supplemental suggestions and support on January 29, 2024, which provided the docket number for the motion to vacate proceedings. The state filed a suggestion in opposition to the notice of proceedings, arguing that the court should not stay Williams's execution while he falsely claims that he is innocent again. This court should not grant a stay based on claims that have already been found to be meritless. The St. Louis County Circuit Court has no authority to reconsider the court's prior decisions denying Williams's claims. The special prosecutor's claims are just as meritless as they were when Williams filed them, and they do not merit a stay. Williams is guilty, and the evidence of his guilt is overwhelming. Williams received effective assistance of counsel. He was convicted and sentenced to death because he committed terrible crimes, not because of his lawyers. The jury that convicted and sentenced Williams was also fair. The court entered an order allowing Williams to file his motion, his supplemental suggestions, and those were filed. Williams filed a leave to reply on January 31st, 2024. That was sustained, and Williams filed his reply suggestions, which weren't even worth repeating here. The Attorney General also filed a motion for leave to file additional exhibit to suggestions to opposition, and that was an affidavit from Keith Larner. We'll talk about all that a little bit more. The court entered an order on March 4th, 2024, sustaining the motion for leave to file the additional exhibit. And then on June 4th, 2024, it issued an order and warrant of execution, setting Williams's execution date for September 24th, 2024. The marshal's return, evidencing service of that on the Office of the Governor, the Missouri Department of Corrections, the Missouri Attorney General, and Marcellus Williams, care of the Department of Corrections, was filed on June 4th as well. Williams immediately on June 5th filed a motion to withdraw a warrant of execution, arguing that the motion under its Missouri section 547.031 should entitle him to a stay of execution. The state opposed that, and because most of the issues relied on in the motion to vacate have already been rejected by the Missouri Supreme Court in Williams' post-conviction and direct appeal. Williams filed a reply on June 10th, which was granted by the court in an order. And then he filed a supplemental suggestion on July 8th. On July 12th, 2024, an opinion was issued overruling his motion to withdraw a warrant of execution, and the court held that the prosecutor's pending Section 547.031 action is not a state post-conviction motion filed by the defendant. In this case, the pertinent state post-conviction motion was Williams's unsuccessful Rule 29.15 motion for post-conviction relief adjudicated nearly 20 years ago. The court's June 4, 2024 order setting Williams' execution date and warrant of execution are authorized by Rule 30.30c. The fact a prosecutor files a Section 547.031 motion is not an automatic basis for a stay. Instead, as in any other case, the offender must show the 4 factors governing equitable injunctive relief warrant a stay. Holding a motion to, no, that's just quoting another case. I'm going to leave that out. Sorry. So they basically overruled his motion to withdraw execution date. And that was entered, an order denying motion for rehearing was entered on July 31st, 2024. So the subsequent state claim is the declaratory judgment. We're going to go to that one first. That was filed in Cole County in the 19th Judicial Circuit under docket number 23 AC-CC05323. The Honorable Cotton Walker was assigned on October 23rd, 2023. Williams was represented by this time by Tricia J. Rojo Bushnell, Charles A. Weiss, Jonathan B. Potts, Barry C. Scheck, Adnan Sultan, Tim Gumkowski, and Hannah Friedman. The state
The
was being
Innocence Project.
yeah, and the Midwest Innocence Project. And he was also being represented at that time by the federal public defender and a Missouri public defender. The state was represented by the AG's office, Andrew J. Crane, Michael J. Spillane, Andrew J. Clark, and Gregory M. Goodwin.
Mickey
Um,
Splain.
I know we talked about that, but
Right.
but Kyle looked him up, and his
Yeah.
first name was not Michael.
Oh.
He was called
Oh,
Mickey,
yeah.
but he had a different first name.
Yeah. Mike Hammer, though. Huh?
Yeah, Mike
Yeah.
Hammer was his character.
Yeah.
That was Stacy Keach on the TV show.
That's right. Seems like yesterday, but it was 40 years ago.
I know, it's so sad.
Yeah.
Yeah, my nephew turned 39 this year.
Yeah. It's
So
crazy when those kids used to be carpet crawlers or have their own family.
I know.
It's awful. Turn
I
back
watch a
time.
lot of Facebook arrest videos, and I'm
Yeah.
like, people getting arrested for shoplifting in Walmart. What year were you born? 1992. I know. This is not fair.
Yeah. Forget that 2002. 2000, yeah.
All right. So we have the petition for declaratory judgment, which was filed August 23rd, 2023 by Marcellus Williams. The defendants were Governor Michael L. Parson and Attorney General Andrew Bailey. The claims count one, the Board of Inquiry process provided to Williams violates his right to due process under the state and federal constitution. Executive Order 23.06 violates 42 U.S.C. 1983 because it deprived Williams of his federal due process rights under color of state law. Count 3, Executive Order 2306 is null and void because Governor Parson lacked the statutory authority to unilaterally dissolve the Board of Inquiry before it satisfied its statutory obligation. And count 4, Executive Order 23-06 violates Missouri's Constitution's separation of powers clause. He requested that the relief requested was that Executive Order 23-06 be declared to have violated his rights to due process under the Missouri and United States Constitution, that the court declare Governor Parsons violated 42 USC 1983 by enacting Executive Order 2306. That 2306 be declared null and void because Governor Parson lacks statutory authority to dissolve the Board of Inquiry. Declare the executive order unconstitutional because it violated the separation of powers clause of the Missouri Constitution. Declare that Section 552.080 of the revised statutes of Missouri does not permit the governor to make the board's report and recommendation wholly confidential, and enjoin defendant Parson from withholding the outcome of the board's investigation, which is my understanding they never issued anything.
Right.
Reinstate Executive Order 17-20 in the Board of Inquiry and enjoin Parson from interfering in its process unless and until it complies with its statutory obligation. Enjoin Bailey from seeking an execution date until the Board of Inquiry satisfies its statutory obligation to produce a report and recommendation. Grant declaratory relief consistent with this petition. And finally, grant such relief as is just and proper. Bailey filed an answer on September 19, 2023. He also filed a motion to dismiss. A joint motion for judgment on the pleadings was filed by Parson and Bailey on September 19, 2023. Several hearings were held. Basically, they were just like status conferences, so I'm not going to go through them. And then on November 16, 2023, the court issued an order that it must accept as true plaintiff's well-pleaded factual allegations. Under that standard, the court holds that plaintiff has asserted viable legal claims upon which relief could be granted, and the court denies defendant's motion for judgment on the pleadings. The court, having ruled on the motion for judgment on the pleadings, does, however, continue to stay on discovery until December 1st, 2023. Absent superseding authority by that date, the parties shall submit a proposed protective order regarding the discovery request related to the Board of Inquiry, and especially any information gathered by that board which is required by the statute to be held by it and the governor in strict confidence, but such pending discovery request shall be answered subject to said protective order once signed by this court. The AG's office was not happy with that decision, so they filed an appeal at the Western District of Court of Appeals in Missouri. That was State of Missouri ex-rel Governor Michael L. Parson relator versus the Honorable Cotton Walker Circuit Judge respondent. That was given docket number WD 86751. It was through a petition for writ of prohibition or any alternative mandamus. That was filed November 29, 2023. The court issued an order on November 30th, 2023, acknowledging the filing of the petition for writ of prohibition or mandamus and the suggestions in support of the petition. Being fully informed, this court does hereby deny this petition for writ. So then the state went to the Supreme Court of Missouri, and that was in docket number SC 100352. The state of Missouri was represented by Andrew J. Clark, Michael J. Spillane, Andrew J. Crane, and Gregory M. Goodwin. Cotton Walker was represented by Tricia J. Rojo Bushnell, Charles A. Weiss, and Jonathan B. Potts, and Williams, an interested party, was represented by Tricia J. Rojo Bushnell. And something tells
I'm sorry. I'm a little the term relator's petition. What is relator refer to?
Well, relator is in an extraordinary action like a petition for writ of prohibition or a petition for writ of mandamus. Prohibition is to keep a state agency or party, a state agency or a court from doing something.
Okay.
Mandamus is to get a court to tell a state agency or court to do something that it refuses to do.
To mandate it. Okay.
Right. So, like if you file, well, we've had a case where years and years and years ago where we were trying to enforce a Florida judgment on a Louisiana citizen, and he happened to be an attorney. And so every time we filed a motion to enforce our judgment, he would file a lawsuit against our client with all these baseless allegations that would basically prevent us from proceeding with our motion to enforce our judgment. And finally, after the First Circuit Court of Appeal gave a very strong opinion about that practice, he had filed another action, and we filed a writ of mandamus with the Court of Appeal saying, tell the court not to let him file these things.
Right. Okay.
Because every time he files it, they dismiss it, and it's
right. He could continually do that just to gum up the works.
Correct.
Unless he's mandated to stop that.
And that it was actually mandating the clerk not to allow him to do it.
What the term relator, or who's that referring to?
So relator is kind of petitioner.
Okay.
They tend to not use in these types of extraordinary writs, they don't use plaintiff petitioner.
Okay.
Because it's a little bit of a different situation, so they call it relator and respondent.
Okay.
And then interested party.
Okay. All right. I've not heard that term before. So
yeah, and it's and some states they may be petitioner.
Right.
In that situation, but in this particular situation in Missouri, they're actually relator. And that's not a very good explanation, but I will look up relator.
I get the point though. Yeah, it's the body who is
Yeah.
petitioning. Petitioner's petition would be too alliterative to use.
So, all right.
I
So,
learned a new word today.
yeah. No, I don't mind at all.
I
Um,
appreciate that.
so and this is funny, like Cotton Walker, the judge, is being represented by Williams's attorneys.
Right. Yeah. It
You
gets
know,
confusing.
like what's wrong with this picture?
Right.
So they filed this. The governor filed his petition for writ of prohibition on December 1st, 2023. On December 5th, 2023, the Supreme Court of Missouri, entered its preliminary writ of prohibition, and it ordered that relator has represented to the Supreme Court of Missouri that you, the said Honorable S. Cotton Walker Judge, Circuit Court of Cole County, have entered an order overruling relator's motion for judgment on the pleadings in case number 23 AC CC 05323, entitled Marcellus Williams Plaintiff versus Michael L. Parson in his official capacity as governor of Missouri, defendant. And whereas relator has represented that your order of November 16th, 2023 violates the law of the state of Missouri. Now, therefore, the Supreme Court of Missouri commands that on or before January 3rd, 2024, you either one, set aside an order said order in lieu thereof, enter an order sustaining relator's motion for judgment on the pleadings, and file notice with this court that you have taken such action, or in the event you choose not to set aside said order, file a written return with the Supreme Court of Missouri in which you show cause, if you have any, why the Supreme Court of Missouri should not issue a permanent writ directing you to do so, to do as set out in 1. In addition, if you choose not to do as set out in 1, you shall take no other action in this cause until further order of the Supreme Court, other than filing your return as set forth above. Walker did file a writ answer on January 10th, 2024, and a response to the order to show cause on the same date. The state filed a brief and appendix on February 9th, 2024. Walker filed a brief and appendix on March 14th, 2024. The governor filed a reply brief on March 25th. Oral argument was held on April 10th, 2024, and the case was argued and submitted. And the opinion was issued on June 4th, 2024, finding that neither Executive Order 17-20 nor Section 552-070 provides a state-created right triggering due process protection. As Executive Order 17-20 illustrates, the Board of Inquiry process is initiated at the governor's sole discretion. Section 552.070 serves as an additional purely discretionary mechanism to assist the executive clemency decision vested constitutionally with the governor alone. Neither the statute nor Executive Order 1720 vested Williams with an existing right triggering due process protection. Governor's executive order dissolving the board and ordering the completion of Williams' sentence in no way denied Williams access to any process to which he was legally entitled. Woodard forecloses Williams' argument he retains a protectable due process interest during the clemency process following his lawfully imposed death sentence and the exhaustion of potential state and federal post-conviction judicial remedies. Section 552.7070 neither creates nor implies any procedural rights for the offender. Williams has nothing more than a unilateral hope for discretionary clemency relief for his lawfully imposed death sentence. His argument distills to a plea for an act of gubernatorial mercy, not a valid argument recognizing due process rights in the governor's exercise of the discretionary clemency power. And they concluded that Section 552.070 cannot and does not limit governor's clemency power. Williams alleged no cognizable liberty of life interest triggering due process protections during the clemency process or restraining the governor's absolute discretion to grant or deny clemency. The governor is entitled to judgment on the pleadings. The preliminary writ of prohibition is made permanent, and all concur. So Williams filed a motion for rehearing on June 17th, 2024. That was overruled on July 12th, 2024, and the judgment was entered on September 3rd, 2024. Upon review of Supreme Court ruling and exhaustion of all challenges thereto, the court hereby enters judgment consistent with such ruling and motion and sustains the respondent's motion for judgment on the pleadings. The judgment was entered. That was by Judge Walker in the Circuit Court. Williams filed an application for stay of execution on September 22nd, 2024, and a petition for writ of certiorari on September 18th, 2024, challenging the state of Missouri's clemency process and the granting of the writ of prohibition and dismissal of his declaratory judgment action. And I'm not going to go into that particular writ because it's not really
doesn't hold up much, does it?
Yeah, I mean it's basically just yeah.
So he was saying, but they were about to pardon me. but let's go back to when I had a governor who was going to pardon me.
Yeah. And so on September 24th, 2024, that application for stay of execution of sentence of death presented to Justice Kavanaugh and by him referred to the court is denied. The petition for writ of certiorari is denied. He also had another state claim going on in the Circuit Court of St. Louis in his original conviction, which was 2199R-05297-01. That was before the Honorable Mary Elizabeth Ott. And this is where his counsel had worked out an agreement with the prosecutor to allow them to interview jurors. And this was so that they could basically do affidavits from the jurors. If I had known all this stuff about Henry Cole and
Right.
Laura Asaro, I would have never sentenced him to death. And, that I don't have those actual affidavits, or I may have them. I don't know, but I didn't. They're not really that. It's the same thing. They go to the jurors and they go to the former witnesses and they tell them they've proven the guy's innocent.
Right.
And they just need the jurors or the witnesses to help them make the courts understand.
Right.
And they feed what they want the witnesses to say to the witnesses.
Right. Yeah, that's an Innocence Project tactic, right?
Mm-hmm. Yeah. And so the court granted an order on August 25th, 2023, permitting Williams's legal team to speak to jurors. Then he had, the next subsequent state claim was the prosecuting attorney, 21st Judicial Circuit of Missouri, ex-rel Marcellus Williams, relator movement. That was in Circuit Court of St. Louis County. Docket number was 24SL-CC 00422 before the Honorable Bruce F. Hilton. The prosecuting attorney was represented by Matthew A. Jacober, Alana M. McMullen, Kelly L. Snyder, and Jessica M. Hathaway. Williams was represented by Tricia J. Rojo Bushnell, Adrian Sultan, and Teresa E. Hurla. And the state, through the Attorney General, was represented by Michael J. Spillane, Gregory M. Goodwin, Andrew J. Clark, Catherine Griesbach, who I wonder if she is related to Michael Griesbach from Wisconsin, and Kristen M. Pride. The prosecuting attorney filed a first motion to vacate or set aside judgment and suggested in support on January 26, 2024. And he basically claims that based on a review of the evidence and additional investigation, the prosecuting attorney has concluded that new evidence suggests that Mr. Williams is actually innocent. Mr. Williams' trial counsel was ineffective for failing to investigate and present evidence to impeach Henry Cole and Laura Asaro. Mr. Williams' trial counsel was ineffective for failing to present mitigation evidence during the sentencing phase. The prosecution improperly removed qualified jurors for racial reasons during jury selection in violation of Batson versus Kentucky. In addition, the prosecuting attorney is undertaking additional review relating to the investigation of Williams that, if true, would demonstrate the investigation was intentionally or recklessly deficient in violation of Williams's right to due process. Additionally, the prosecuting attorney is undertaking additional investigation relating to an alternative perpetrator in this matter that may confirm or deny the involvement of a person other than Williams in this crime. That additional investigation will involve forensic testing and other investigation that will take some time. Due to the evidence as it exists today, as well as the ongoing investigation, the prosecuting attorney believes it is incumbent upon this office to begin the process of asking this court to correct this manifest injustice by seeking a hearing on the newfound evidence and the integrity of Williams's conviction. This request is made all the more urgent because the Attorney General's office has requested an execution date for Williams. So the alleged new evidence is that 3 DNA experts would now exclude Williams as the source of male DNA found on the knife left in Lish's body.
Which they didn't say in the initial trial that it did
Correct.
have. Right.
Correct. He was never linked to anything in the original trial.
Right. So that's not really new evidence, but they'll
No,
dress it up as.
it is
Yeah.
not. It's like I thought of this the other day when I was looking at the crap that Reed's attorneys filed
Mm-hmm.
in his latest writ, which
Yeah.
I think I'm probably going to have to do like a mid-season update show
Yeah.
because of the crap that's been going on
If
out
they
in
ever
the true
announced that
crime
they've
world.
received it, it's weird that they haven't not publicized the fact that not to get off track here, but is
Yeah,
there
I don't
any?
understand why that. I have been waiting for a post from Laura Burston on Twitter for ages now. And but Crystal has made a troubling comment on Facebook, and I might reach out to Deborah. Right now, they're going through so much with their mom. I don't want to.
Yeah.
I don't. But once things settle down with her mom, I'm going to reach out to Deborah because Crystal made a comment that I inferred that someone from the AG's office or Bastrop has told her they're just going to let Reed die in prison.
Yeah.
That they're not going to seek another date.
I mean, I get that. It's that's crossed my mind too. Which, in light of the case that we're discussing here, they do put people to death still in Texas, but I think that maybe the Innocence Project has done such a good job at PR with this one, with Rodney Reed, that they have just created a situation where they can't really execute him, because people will just be saying that they're executing an innocent person, regardless of the mountain of evidence.
Yeah, but I also working in the law field, I
Yeah.
know from experience that sometimes we have to-do lists and we have things that come up that get put before other things on that list. And so things on the to-do list keep getting shuffled down further and further.
Yeah.
Because we have time-sensitive deadlines that we have to meet first. And the attorney who has been involved in the Rodney Reed case is also involved with Robert Roberson.
For the state.
So, but it would be the DA in Bastrop who actually asked for an execution date, not the AG's office.
Yeah.
Although the AG's office can, if the DA in Bastrop isn't going to, as we saw with Anderson County, with Roberson, because the DA in that case, in that county, wasn't going to ask for a date. And Paxton's office said, oh, no, we're not going to do that. So we'll have to see. But I want
Yeah.
to talk to I want to talk to Deborah before
Yeah.
to see if they have gotten that from victim services in Bastrop,
I'd
that
be
they're going to
interested.
just let it, yeah.
Yeah.
And I'm not gonna publicize it, but I will definitely personally let you know.
Appreciate that. All right, let's
Um,
get back to
so anyway, all right. So that isn't new evidence because they had the new just because you just got these DNA experts to weigh in
right,
doesn't make it new because they're weighing in on testing that was done in 2017
right,
or 2015. So um, family and friends of Colin Asaro would testify they were known liars who worked as informants for police. That is definitely not new, and
right.
the prosecutor wasn't even relying on current affidavits. He was relying on affidavits filed in a post conviction action in 2003.
And I'm sure that the defense kind of poked holes in there or tried to poke holes. So,
Yeah,
the, so that's not new either because the original jury probably did know that they weren't pristine people.
correct.
Yeah,
And the other thing too that a lot of people don't realize is, especially with this case, about I would say 90% of what those affidavits said would have been inadmissible at a trial before a jury
right.
because it's not admissible to come in and trash a state witness with purely he's just a liar. I think he's a liar. He's never
Right.
told the truth in his life. That's all just trashing a witness. It's
Yeah.
not admissible
It's
any
hearsay.
more than the state could have somebody come in and do that to the defendant.
Yeah.
It wouldn't be admissible with the defendant unless the defendant or somebody for the defendant testified he's as honest as the day is long.
Yeah.
And then you can bring in rebuttal, but in the direct case you can't do that.
Yeah. There's
So
not to go back to the Reed case, but when the person testifying against Jimmy was was a known forger, and
right,
I
yeah.
mean that's kind of something you can bring up to call someone a liar if they're serving time for forging.
Mhm.
But
Yeah.
otherwise, yeah, this doesn't seem like new evidence.
And in the Reed case, let's just put it out there, the reason the relationship witnesses weren't found to be credible and the new ones aren't going to be found to be credible is because none of them gave any of this information to police in 1996
Yeah,
when Stacy was murdered,
the
or
previous millennium. Yeah,
1997 when Reed was arrested, or
right.
1998 when he was on trial for capital murder. Y'all all remained silent, and then you come forward 30 years later.
Probably after you had a little meeting with the Innocence Project in one of their big rooms with a whiteboard that
Hmm.
said, wouldn't it be interesting if you did this? And wouldn't you
Yeah,
like to go on Maury Povich or Dr. Phil?
I think Maury Povich is deceased now.
Okay, yeah,
I believe he passed away
is he dead?
shortly.
Okay,
Yeah, so's
well,
Jerry Springer.
and Dr. Phil doesn't have a show anymore. He's
Dr.
bankrupt. So
Phil's show went kaput. Yep.
yeah,
Although he
so
does have like an internet platform.
but it's bankrupt.
Yeah.
He just yeah. So but so I guess that puts a little problem in the cog
Well,
of the Innocence
there's still
Project.
Steve Wilkos.
Oh, okay. He used to
He's
be Jerry
he's
Springer.
he used to be yeah, I think he was like a security for Springer.
Yeah.
Yeah. Anyway,
Anyway,
so and the that kind of crowd also will work with Kelly Clarkson and Tamron Hall and some of
yeah.
these
The
other
Dr. Phil thing really kind of bothered me so much. Again,
yeah,
not to go off into read, but yeah, but that I mean it was Bryce Benjet, right? Was on that show, and
correct.
he just did a fantastic job of just leading the witnesses where they wanted them to go. And
Mm-hmm.
you could just imagine, or at least I could just imagine the meeting at this, big downtown New York office of the Innocence Project and saying, well, wouldn't it be good, and like this, wouldn't it be good if you knew the Cole and Asaro were liars? Can't you come up with some reasons to think that they would be? And if you could,
Right.
then anyway, all right.
All right. So then alleged new evidence. Roberts would confirm that Asaro was the source of the laptop based on Williams' statement that Williams got the laptop from his girlfriend, who asked him to sell it for her. Well, again, that's not new. Williams tried to raise that at trial. It was not admissible, and the direct appeal found that it was not admissible. So none of this alleged new evidence is even new.
No, but they dress it up like that so that
Mm-hmm.
they
Yeah,
can also put out a press release and a web page saying
right. It's not new just because you say it is.
correct. Yeah.
So claim one, new DNA evidence in light of the undermined witness testimony suggests Williams may be actually innocent. 3 DNA experts exclude Williams as the individual who stabbed Felicia. New evidence substantiates that Cole and Asaro were known unreliable witnesses who would like to help themselves. Evidence not heard by the jury reveals the laptop is linked to Asaro, not Williams. Claim 2, trial counsel was constitutionally ineffective in failing to investigate and present available evidence to impeach the credibility of state witnesses. Trial counsel was ineffective for failing to investigate and impeach Cole. Trial counsel was ineffective for failing to investigate and impeach Asaro. Claim 3, trial counsel was ineffective in failing to investigate and present available mitigation that would have caused at least one juror to return a life verdict. And claim 4, improper removal of qualified jurors for racial reasons violated Williams' constitutional rights and Batson's. St. Louis County prosecutor's pattern and practice, alleged pattern and practice, and state violated Batson during Williams' trial. Again, all these issues have been raised, and the Supreme Court of Missouri has shot down each and every one. So I'm just going to put this out there. A circuit court in the state of Missouri cannot find any way other than what the Supreme Court of Missouri has already found as to these issues.
Right.
And the prosecutor knows this.
Right.
So, like I said, maybe he thought, like, as Allah Adnan said, the fix was in. The attorney general.
Should they direct this to the circuit court then, or instead of the
Well,
state court?
no. If anything, the only court that he could have directed it to was the Missouri Supreme Court, but the Missouri Supreme Court is not going to say, "Oh, well, we were wrong."
Yeah, they
And
already
yeah,
ruled on it.
now we're going to find that all this stuff is,
Right.
grounds for reversal. No, that's not
Right.
going to happen.
Yeah.
Because it's not,
Right.
and there are very good reasons why it's not, which I think we talked about in episodes 1 and 2.
Right.
The Attorney General filed a motion to dismiss the motion to vacate or set aside on June 5th, 2024. Argued the court was without authority to stay Williams' execution, that following the Supreme Court of Missouri's issuance of an execution warrant, the court may lack jurisdiction or authority to consider movement's motion to vacate or set aside Williams' conviction. And argued that their analysis of the Missouri Constitution requires this court to dismiss movement's motion to vacate or set aside Williams' conviction and sentence. Movement's first claim that Williams may be innocent of first-degree murder has already been denied by the Supreme Court of Missouri. DNA evidence, Williams' expert on direct examination that Williams could not be excluded from the DNA profile, that if more profile locations were above 300 RFU in the sample and those locations were not consistent with Williams, she could have potentially made conclusions off of the data. On cross-examination, she noted that loci above 300 RFU, the strongest results, matched Williams, There would be no further value in additional DNA testing because the DNA had been consumed. Williams had Williams told Cole that he wore gloves during the crime, and the trial prosecutor filed an affidavit stating that he had handled the knife without gloves because all testing had been completed in 2001. The impeachment material, the Supreme Court of Missouri found the alleged impeachment testimony was cumulative. Impeachment evidence cannot form the basis for a freestanding innocence claim because it is not new, as it was available at trial. And the laptop, the Supreme Court of Missouri found the circuit court properly excluded the evidence as self-serving hearsay. Movement's second claim that Williams' trial counsel provided ineffective assistance in failing to impeach the state's witnesses has already been denied by the Supreme Court of Missouri. The Supreme Court of Missouri has already denied Movement's claim on behalf of Williams regarding Cole and on behalf of Williams regarding Asaro. Movement's second claim has already been presented and rejected by the Supreme Court of Missouri. A lower court may not review these claims again. Movement's third claim that Williams' trial counsel provided ineffective assistance in failing to present different mitigating evidence contextualizing Williams' troubled background has already been denied by the Supreme Court of Missouri. It's also been found by the Eighth Circuit Court of Appeals to be the Eighth Circuit's also found that the trial counsel wasn't ineffective in the mitigation stage. Movement's fourth claim that the state committed Batson violations by exercising peremptory strikes of jurors on the basis of race has already been denied by the Supreme Court of Missouri. Alternatively, even taking every allegation in Movement's motion as true, claims 3 and 4 fail as a matter of law because the allegations do not plead a constitutional violation that undermines the confidence in the judgment in Williams' case. Williams filed a motion to strike respondent's motion to dismiss. Movement also filed a response to the motion to dismiss, arguing that the Attorney General cannot file dispositive motions before a hearing, that this court has jurisdiction and authority to hear this matter based on the plain language of 547.031 and Rule 3030. That certain claims contained in the motion to vacate are not barred from being heard by this court due to being previously raised, and that the Attorney General's motion to dismiss could be converted into a motion for summary judgment if considered at all. Sorry, that's our oven, if anybody heard it. Marcellus Williams filed a response to the motion to dismiss as well. Arguing that the statutory delineated role of the Attorney General does not allow for the filing of dispositive motions prior to a hearing, and also arguing the plain language of 547.031 requires the court to hold a hearing on the motion to vacate, that the Missouri Supreme Court's prior rulings in Williams' case have no bearing on whether this court can consider his claim of innocence raised in Bell's motion to vacate, and that Bell's motion to vacate states an innocence claim on which relief can be granted. Suggestions in opposition to the motion to strike were filed by the Attorney General, which I'm not going to detail. An order was entered on July 2nd, 2024, setting a hearing on August 21st, 2024 at 8:30 a.m. on the motion to vacate and the motion to dismiss filed by the Attorney General, as well as the motion to strike. The parties are to meet and confer on a scheduling order for discovery, and expedited discovery is being permitted. The Attorney General filed a reply in support of its motion to dismiss on July 3rd, 2024, basically just countering the arguments made by Williams and the prosecutor. A supplemental DNA case report was issued on August 19th, 2024 by Bode Technology. It had been requested by the Innocence Project in New York. Bode received reference samples for Keith Larner, the prosecutor, and Edward McGee, a DA investigator. Bode developed YSTR profiles from Edward McGee and found that his profile was identical to the look I reported from the prior YSTR analysis of the knife handle, proving that an investigator handled the knife at trial without wearing gloves. I believe Larner's DNA was also found in a mixture on that of that prior YSTR testing as well.
What year was that? Would that have happened? Was that
That would have been in 2001.
okay?
Evidence handling was
Yeah,
becoming stricter, but it was not quite as strict as it is now.
right. Because touch DNA was not
Correct.
a thing
Correct.
back then.
It was a theory, but it wasn't in
Right,
practice yet. And it's interesting because, like, people have referred to the O.J. Simpson case. The only reason witnesses handled those gloves with wearing gloves is because they had blood on them,
right,
and they were wearing gloves to protect them from potential contaminants in the blood, not to preserve evidence
oh, right.
on the gloves.
Yeah, because that's 1994, right?
Correct. So, um, and that was, once everything had been done with the fingerprinting and swabbing and whatever was going to be done with the knife, then you didn't have to preserve anything. There was nothing to preserve.
Right.
They'd gotten all they're going to get. The hearing was held on August 21st, 2024. And that was where the fix was in, because it was in light of those DNA results that do not identify an alternate perpetrator, but show that the DNA on the knife belongs to an investigator and the prosecutor. Williams and Bell came to an agreement to enter an Alford plea.
And that is, I'm guilty. I'm not guilty, but I'm going to stop defending myself.
That I'm not guilty, but the state could prove me guilty at trial beyond a
Okay.
reasonable doubt, so I'm going to enter this guilty plea.
Right.
Similar to the West Memphis 3.
Right.
So on August 21st, the court entered an order after that, and I think I put the press release and the order in the wrong order. My apologies, Patrick.
That's right.
So August 21st, they have a brief little hearing. Williams and Bell say, hey, we came to an agreement. We're going to enter an Alford plea. The
Right.
Attorney General says, no, you can't do that. Judge, you don't have the right to do that. They bring in Licia's family saying, well, Licia's family wants this over with. And so the judge says, I can do that, and I'm going to do that, and this is what we're going to do. So the court enters a consent order and judgment. The court has been informed the state of Missouri through the St. Louis County prosecuting attorney and Williams have agreed to settle this matter as follows. The conviction and sentence as to count 2 only shall be vacated, conditional upon Williams pleading to the charged offense of murder in the first degree pursuant to North Carolina versus Alford, 400 U.S. 25, 1970, with a negotiated sentence of life without the possibility of parole for the charge of murder in the first degree, with the other counts upon which Williams was found guilty after a trial and subsequently sentenced remaining unchanged. The court finds the state of Missouri through the St. Louis County prosecuting attorney concedes that constitutional error did occur in the original trial that undermines confidence in the original judgment. The court finds that following discussions between a representative of the victim's family and both the prosecuting attorney's office and the attorney general's office regarding the consent judgment, the court held a telephonic conference in chambers with that representative on August 21st, 2024, wherein the representative expressed to the court the family's desire that the death penalty not be carried out in this case, as well as the family's desire for finality. The court has been informed that Williams acknowledges, understands, and agrees that by being represented pursuant to this judgment, he waives his right to appeal or collaterally attack the judgment, resentencing him following the entry of this judgment, except on grounds of newly discovered evidence or changes in the law made retroactive to cases on collateral review. The court finds that the state of Missouri, through the St. Louis County prosecuting attorney and Williams, are the proper parties to this negotiated settlement of this matter pursuant to Section 547.031. And then, oh wait, oops, let me go back. No, I'm confusing myself here.
So you're going.
Okay. The court further finds, in accordance with Revised Statutes of Missouri, Section 547.031, 2, the Attorney General has been given notice of the motion to vacate previously filed, has entered its appearance, and has participated in all proceedings to date, including providing its objections to the instant consent order and judgment. The court, after taking judicial notice of the motion to vacate, the evidence presented at the original trial, direct appeal, and post-conviction proceedings, including all state and federal habeas actions, finds this consent order and judgment is supported by the record, and the court further finds that all other pending matters or motions before the court in this proceeding are hereby denied. Wherefore, the court vacates the conviction of Marcellus Williams for murder in the first degree, count 2, on the condition that Marcellus Williams accepts a plea of murder in the first degree and a sentence of life with the possibility of parole to be imposed.
Mhm.
So then the Attorney General issued, after this hearing, and I don't see this necessarily as a fix with the judge. I think Bell and Williams just kind of steamrolled the judge into doing what they wanted done. And I'll go into that a little bit more later. So at 2:56 p.m. that afternoon, the Attorney General issues a press release. Attorney General Bailey opposes Marcellus Williams' consent judgment and shines light on new DNA evidence. Jefferson City, Missouri. Today, Missouri Attorney General Andrew Bailey announced new evidence came to light proving his office's assertion that the DNA on the knife in the Marcellus Williams case was a match for a member of law enforcement who had handled the knife during trial. The St. Louis County Prosecuting Attorney's Office wrongfully asserted the DNA evidence would prove Marcellus Williams did not commit the murder because it would be a match for a mystery killer. I am proud of how hard we have fought for the rule of law in this case. Throughout all legal games, the defense created a false narrative of innocence in order to get a convicted murderer off of death row and fulfill their political ends. Because of the defense's failure to do their due diligence by testing the evidence that supposedly proved their point, the victims have been forced to relive their horrific loss for the last 6 years, said Attorney General Bailey. The victims in this case deserve better. Missourians deserve better. In this case, a new round of DNA testing proved the Attorney General's office was right all along. The knife in question had been handled by many actors, including law enforcement, since being found. This was proven correct by the defense's own DNA evidence, which proved an investigator handled the knife at trial without wearing gloves. In addition, one of the defense's own experts previously testified he could not rule out the possibility that Williams's DNA was also on the knife. He could only testify to the fact that enough actors had handled the knife throughout the legal process that others' DNA was present. In addition, all the evidence the jury relied on to convict the defendant remains intact. The victim's personal items were found in Williams's car after the murder. A witness testified that Williams had sold the victim's laptop to him. All of the evidence in question was available at trial. Instead of taking the opportunity to prove his innocence at the hearing scheduled for today, Williams will plead to a crime he claims he did not commit. No innocent man is willing to spend the rest of his life in prison unless he knows he is guilty. Attorney General Bailey concluded the juries of the state of Missouri under the Sixth Amendment have a right to participate in the process, and someone needs to assert the jury's determination in the legal process. Too often, people forget about all of the evidence that was used to convict the defendant, the evidence the jury relied on, and the victims. The public has been deceived every step of the way. This is why the truth of this matter must get out.
Yeah, that follows what I said at the beginning of our podcasts. The people are looking at the headlines, right? They're not
Hmm.
looking at the details of the case,
Yeah.
and people want the press and the people in general want a story about a wrongly convicted man more so than they want the story of uh, evidence that sealed his fate back decades ago.
Hmm. All right. So uh, the Attorney General was not giving up, as you can guess from his press release.
Right.
He filed an action at the Supreme Court of Missouri, SC under it was under docket number SC 100707, State of Missouri ex rel Andrew Bailey Relator versus the Honorable Bruce F. Hilton Circuit Judge Respondent. He may have also filed something at the Eastern District Court of Appeal, but they denied the writ. Um, there are so many actions where Marcellus Williams' name appears that I may have missed something here or there, but I think I caught the biggest ones. Um, so the Attorney General was represented by Gregory M. Goodwin and Michael J. Spillane, and Judge Hilton was being represented by Matthew A. Jacober, who was the special assistant in the prosecutor's office. And that's a little unusual to me too.
Yeah.
But maybe in Missouri, when you're challenging a judge's ruling with a writ like that, maybe they don't get their own counsel they rely on the winning counsel to defend their decision. I don't know. Um, Again, on August 21st, they filed a petition for writ of prohibition or in the alternative mandamus and suggestion and support. The errors for review were that the respondent exceeded his authority by granting a consent order without the consent of all parties because the Attorney General objected. Respondent exceeded his authority because no evidence was presented to satisfy movement's burden under 547.031, and the statute only permits respondent to grant relief if movement proves by clear and convincing evidence that the convicted person is actually innocent or that there was constitutional error at the original trial or plea that undermines constant confidence in the judgment. Third, respondent exceeded his authority by granting a consent order without a legal basis for granting the order. And then the Attorney General also filed a motion to dispense with time limits under Rule 84.24 because they wanted to expedite this process they wanted to expedite issuance of the preliminary writ because a new sentencing was scheduled for August 22nd, 8:30 a.m., where the court was going to sentence Williams to life in prison.
So this is the day before.
Correct. Correct. Motion for emergency or administrative stay was also filed, seeking a stay of all proceedings in the St. Louis Circuit Court while the Missouri Supreme Court evaluates the Attorney General's writ. And that is just to prevent that sentencing hearing from going forward. The Supreme Court did issue its preliminary writ on August 21st, and it commanded that on or before August 22nd, 2024, Judge Hilton either sets aside said consent order and judgment and file notice with this court that you will take action required by 547.031, including holding the evidentiary hearing previously scheduled and anticipated, permitting the Attorney General to participate pursuant to Section 547.031 and Section 27.060, and following such evidentiary hearing required by Section 547.031, applying the burden of proof set out in said statute, make findings of fact and conclusions of law as required by Section 547.031 in a timely manner, but no later than September 13th, 2024, or in the event you choose not to set aside said consent order and judgment, file a written return with the Supreme Court of Missouri in which you show cause, if you have any, why the Supreme Court of Missouri should not issue a permanent writ directing you to do as set out in Section 1. In addition, if you choose not to do as set out in Section 1, you shall take no other action in this cause until further order of the Supreme Court other than filing your return as set forth above. On August 22nd, and this is why I believe Bell and Williams just kind of bullied Judge Hilton into doing what they wanted, because he immediately issued an order on August 22nd, 2024. Wait, this was the Supreme Court on August 22nd issued the order overruling the relator's motions as moot. Darn it. I'm sorry.
What's wrong?
I got something mixed up. Basically, I got so mixed up when I was doing this. I'm really sorry.
Well,
the Judge Hilton issued an order vacating his order, but I had it in a different place. So the Supreme Court ruled that the motion to dispense with time limits was moot because the judge did issue an order rescinding the consent order and judgment and setting a hearing. But we'll get into that when we go back. That's why I said there was so much.
Yeah. There's a lot of layers going on. Yeah. Shenanigans.
So the Attorney General filed another press release or issued another press release on August 22nd at 9 a.m. And
so they're setting a new hearing.
Yeah. Today, Missouri Attorney General Andrew Bailey announced that the Missouri Supreme Court sided with his office and issued a preliminary writ forcing the trial court to comply with the law and hold an evidentiary hearing in Marcellus Williams' case. It is in the interest of every Missourian that the rule of law is fought for and upheld every time without fail, said Attorney General Bailey. I am glad the Missouri Supreme Court recognized that. We look forward to putting on evidence in a hearing like we were prepared to do yesterday after the Missouri Supreme Court issued the court order forcing the lower court to comply with the law. The trial court scheduled a new evidentiary hearing for August 28th at 8:30 a.m., where the defense will be allowed to put on evidence. Attorney General Bailey will then remind the trial court that in this case, a new round of DNA testing proved the Attorney General's office was right all along. The knife in question has been handled by many actors, including law enforcement, since being found. In addition, all evidence the jury relied on to convict the defendant remains intact, instead of taking the opportunity to prove his innocence. And that's all from the prior press release. We're not going to go into that again. The preliminary writ that was issued was quashed in light of the order and judgment filed in St. Louis Circuit Court, case number 24 SLCC-00422, and the petition for writ of prohibition was denied as moot. So we go back to the Missouri Circuit Court, St. Louis Circuit Court, and the order and judgment was entered scheduling the hearing. And then the hearing was held on August 28, 2024. The cause called, heard, and submitted. Parties shall submit proposed findings of fact and conclusions of law by September 4th, 2024. The prosecutor and Williams submitted proposed findings of fact and conclusions of law on September 4th, 2024. They also got, quote, concerned citizens to send correspondence to the court on September 8th and September 9th, and these were form letters, 13 form letters, addressed to Judge Hilton, expressing doubts about Williams's guilt, playing the
Hmm.
race card, i.e., asserting that Williams was sentenced to death because he is black and his victim was white, and calling his sentence an injustice. The letters each informed Judge Hilton that I am not interested in supporting your retention as a judge if this execution goes through. None of the letters bore any information about senders other than their names, i.e., there were no addresses that would prove they were St. Louis County voters.
They were
And
interns at the Innocence Project.
well, they could have been anybody really. There were a lot of internet petitions,
Yeah,
and basically what they do is they produce this form letter and encourage everybody
yeah,
to send it to the judge, and they don't care whether you're in the jurisdiction or not.
right.
So, um, on September 12th, 2024, the Judge Hilton issued his findings of fact and conclusions of law, order, and judgment. He denied the Attorney General's motion to dismiss. He made findings regarding the movement's witnesses at the hearing on August 28, 2024. And I'm just going to go through those as quickly as I can because I know we're getting up on 2 hours. I
Yeah.
didn't think
How's
we'd
your
take
voice
this
doing?
long. It's doing okay. I think I
Okay.
can. I think I can make it because it speeds up a little bit after this, or I'll speed it up. um, David Thompson, an expert for the defense, testified over the state's objection concerning the reliability of witnesses Cole and Asaro. Thompson concluded, based upon evidence-based standards, that Cole and Asaro gave unreliable information to investigating officers. And this is the old, parsing what they said in one statement and what they said in another statement, and paraphrasing their trial testimony
Right.
and making it look like they didn't have their story straight.
As if they were professional witnesses.
Right.
Yeah.
Thompson acknowledged that he did not review the trial transcript, which included the trial testimony of officers who interviewed Cole or Asaro, or the trial testimony of Cole or Asaro themselves. So how can he know whether it's reliable or not
Right.
if he doesn't even look at it?
Right.
Had he done so, he would have had the opportunity to confirm trial counsel's exemplary efforts to discredit the testimony of Cole and Asaro in the presence of the jury. Despite trial counsel's efforts, the jury found the testimony of Cole and Asaro to be credible. Thompson's testimony regarding the reliability of testimony provided by Cole and Asaro does not aid in deciding the issues currently before this court. Honorable Joseph L. Green, one of Williams's trial attorneys. Judge Green testified that he did not recall one way or the other whether anyone touched the knife without gloves during trial. This court finds that Judge Green testified earnestly, compassionately, honestly, and to the best of his recollection, but as he admitted, his memory was better at the time he testified in Williams's post-conviction relief case in 2004. Despite Judge Green's testimony that he believes that Williams did not get our best, this court disagrees. Based upon review of the trial transcript, PCR transcript, and Judge Green's affidavit, Judge Green, without reservation, performed his duties as trial counsel in an exemplary fashion. Judge Green's testimony before this court does not support either of the claims of ineffective assistance of counsel raised in Movement's motion to vacate, which was already rejected by the Supreme Court of Missouri. Dr. Charlotte Word, expert, the court finds that Dr. Word's testimony established three important facts. One, the DNA material found on the knife handle likely belongs to investigator McGee and also possibly Larner, and not to some other yet to be identified individual alleged by Williams and Movement to actually be responsible for the murder of Felicia. Two, if DNA material from the murderer was ever present on the knife handle, any such material could have been removed by individuals subsequently touching the knife handle without gloves. And three, Dr. Word had no idea what the procedures for evidence handling were in the St. Louis County Prosecuting Attorney's Office or in any crime lab for any St. Louis law enforcement entity at the time of the investigation into Felicia's murder or at the time of Williams's trial. The court finds that Dr. Wood's testimony does not bolster Movement's claim of actual innocence. Movement claimed that DNA material of the actual killer was on the knife handle. This theory was clearly refuted by Dr. Wood's testimony, and in addition, Dr. Wood's testimony provides no support for the theory of bad faith destruction of evidence. Because when in typical fashion they move the goalposts. So when the DNA evidence doesn't support their claim, they allege a young blood violation for contamination of evidence.
Yeah.
Judge Christopher McGraw, also trial attorney. Judge McGraw testified he does not remember anyone touching the evidence outside of the evidence bag without gloves. Judge McGraw testified that he was not told prior to trial that an investigator had been handling the knife without gloves. The court finds that Judge McGraw testified credibly as to his recollection of events, but the court notes that he had difficulty remembering events of the trial in 2001, roughly 23 years ago. This court also finds that his memory that no one handled the knife without gloves is not consistent with the record and the evidence before this court, including the fact that he was present in the courtroom when the knife handle was held without gloves. Keith Larner, prosecutor, Larner testified that the two informant witnesses, Cole and Asaro, were the strongest witnesses he ever had in a murder case. Larner testified that Cole knew things that only the killer could know. Larner testified that Cole knew the knife was jammed into Licia's neck, that the knife was twisted, and that the knife was left in Licia's neck when the murderer left the scene. Details which were not public knowledge. Larner testified that Asaro was amazing. Larner testified that she led police to where Williams pawned the computer taken from the residence of the murder scene, and that the person there identified Williams as the person who pawned it. Larner testified that Asaro also led police to items stolen in the burglary in the car Williams was driving at the time of the murder. Larner testified that he knew from talking to Detective Vaughn Creech that the killer wore gloves. Larner testified that he believed it was appropriate to handle the knife without gloves after the crime laboratory had completed their testing, after he was informed that no one wanted any more testing on the knife, and after he was informed the laboratory found there were no fingerprints and nothing to link any individual to the crime. Larner testified he handled the knife without gloves at least 5 times prior to trial. He showed the knife to 4 witnesses, 2 detectives, Licia's husband, and the medical examiner, and affixed an exhibit sticker on the knife for use at trial. Larner testified credibly that he had never heard of touch DNA in 2001 and probably did not hear of it until 2015. Larner testified that the standard procedure in the St. Louis prosecuting attorney's office at the time of Williams's trial was not to wear gloves when handling fully tested evidence because there was no reason to. Larner testified that he did not open untested fingernail clippings at trial without gloves because he did not want to contaminate them. Larner recalled that he had used 3 peremptory challenges on African Americans because the Missouri Supreme Court listed 3 Batson challenges addressed in Williams's direct appeal. The additional 3 peremptory strikes of black jurors were not challenged in Williams's direct appeal. Larner denied systematically striking potential black jurors or asking black jurors more isolating questions than white jurors. The court finds that Larner had a good faith basis and reasons for handling the knife without gloves, despite Dr. Word's testimony that agencies that collected evidence at or near the time of the murder knew about the importance of properly collecting evidence to preserve any biological substances. Patrick Henson was an investigator for the prosecuting attorney. Henson testified that he did not find Larner's notes from jury selection in the file retained by the St. Louis prosecuting attorney's offices during the review of the file sometime in 2024. Henson testified he had no knowledge of where or how long the file was stored, nor what the file did or did not contain at any time prior to 2024. Henson reviewed the Williams file and did not find any notes from the prosecutor pertaining to voir dire. Henson also testified that he never reviewed the state's trial exhibits, which were in the possession of the Missouri Supreme Court, and that no attorney from Movement's office ever asked him to retrieve those exhibits. This court finds that Henson testified credibly and to the best of his ability, and that his limited knowledge of relevant facts with what procedures were in place for file retention during the years in question undercuts the probative value of his testimony to any issue presently before this court. So, those are the findings.
Yeah.
And basically, it's that Movent did not carry his burden.
Right. Not in. Yeah. Not in the least bit. Right. I mean, everything is a non-starter. Really. It's too bad
Mhm.
that so much effort had to go into this because I mean, I guess if you put that type of uh, uh, a, a movement through the courts, they've got to address it.
Mhm.
But it really,
Yeah.
the right. I mean, everything was a non-starter, and
Yeah. Yeah.
yeah,
I mean, it was based on a fallacy
yeah.
because none of what it was based on was actually new.
But they worked
Um,
hard to get it in the process of the courts, and they
right.
were successful in doing that, which I guess is part of the. Again, if it is Innocence Project, I think part of their goal. I mean, part of their goal is to obviously be successful in court. The other part of their goal is to get headlines and to show people that they're working hard.
Mhm.
So the PR part of it was very successful, even if the court part of it was not.
Right. All right. So, conclusions of law. Claim one: Williams may be actually innocent of first-degree murder. Generally, in support of his claim that Williams is innocent, Movent alleged that DNA testing excludes Williams as the person whose DNA was found in the knife used in the murder, that members of Cole's family would provide testimony that Cole is a liar and known informant, that Assaro's friends would provide testimony that she is a liar and known informant, and that Roberts, to whom the stolen laptop was sold, was prevented from testifying about where he learned Williams obtained the laptop. Prior to the enactment of 547.031, offenders who were sentenced to death could raise a freestanding claim of innocence in the Supreme Court of Missouri. Williams asserted such a claim before the Supreme Court of Missouri. The Supreme Court of Missouri has heard the majority of the DNA evidence movement now asks this court to consider, with the exception of the recent DNA results, that weakens Movement's claim and demonstrates that Investigator McGee is the likely source of the DNA on the knife. Further, the Supreme Court has already denied that claim. Further, the Supreme Court of Missouri has already determined that the other evidence underpinning Movement's first claim allegations of the existence of impeachment material concerning Cole and Asaro were at least in part not admissible at Williams's trial. The same is true about self-serving hearsay concerning the location of the laptop. Claim 2, Williams' trial counsel provided ineffective assistance of counsel by failing to investigate and impeach Cole and Asaro. Williams has raised these claims before. The Supreme Court of Missouri rejected Williams' claims that his counsel provided ineffective assistance regarding investigating and impeaching Cole and Asaro. After considering the entire record, the Supreme Court of Missouri denied each of these claims. Claim 3, Williams' penalty phase counsel provided ineffective assistance by not presenting a penalty phase defense based on Williams' allegations that he experienced an abusive childhood. And I'm not really going to go into that because that was really that wasn't a big factor during the post hearing press. But basically, again, it's he didn't meet the Strickland standard, and this has been decided by other courts.
Right.
Claim 4, the state exercised discriminatory peremptory strikes of two members of the veneer person 64 and veneer person 65. That's the Batson challenge. The Supreme Court of Missouri rejected Williams' Batson challenges to these same veneer persons on direct appeal. The Supreme Court of Missouri found that the state had provided race neutral reasons to support its strikes of veneer person 64 and veneer person 65. And I don't know if you remember, one was a postal employee who looked a lot like Williams.
Mm.
One was a guy who was, I think, dishonorably discharged for lying or stealing in the military.
And they're claiming that,
which he may
Cameron,
not even be eligible to serve on a jury.
right.
And the third was a guy who got fired for getting into a fight at work and then seemed to get a little upset when jurors laughed at his telling that story.
Oh, all right. It's the guy you want sitting next to you for a week,
Yeah,
2 weeks.
like yeah, because if he gets upset at
Right.
that, I mean, how's he going to feel if you don't agree with him?
Yeah.
Um, but anyway, so the Supreme Court of Missouri found the state provided race neutral reasons to support its strikes of veneer persons 64 and 65. I'm not sure. I know one is the postal employee. I'm not sure whether one is the military guy or the angry guy. Our Missouri Constitution vests the state's judicial power in a Supreme Court, a Court of Appeals, and circuit courts. It further provides the Supreme Court shall be the highest court in the state. Its decisions shall be controlling in all courts. So basically, because movements first, second, third, and fourth claims before this court have previously been denied by the Supreme Court of Missouri, when the very same claims were raised by Williams in his 547.031 motion, this court must now deny them. Claim 5, the state engaged in bad faith destruction of evidence under Arizona versus Youngblood, 488 U.S. 1051, 1988, from the amended motion, which was filed shortly before the hearing over the state's objection. Movement alleged bad faith destruction of evidence occurred when police destroyed fingerprint lifts determined to be without evidentiary value, and when the prosecutor and his investigator touched the handle of the murder weapon without wearing gloves. Movin and Williams have made arguments before this court indicating that the knife handle was central to the state's case, or that without additional unblemished testing, Williams has no avenue to prove his actual innocence. The United States Supreme Court has specifically refuted similar arguments that have also attempted to change or remove the bad faith requirement of Youngblood. Here, neither Movent nor Williams presented any evidence from which this court could find that the state destroyed potentially useful evidence in bad faith, let alone clear and convincing evidence of same. The record before this court refutes the allegation of bad faith destruction of latent fingerprints. Indeed, the trial transcript indicates that latent fingerprints of insufficient quality for comparison were destroyed. Specifically, Detective Thomas Crossley testified that he received fingerprint lists that were of insufficient quality to be used for comparison, and those were destroyed after it was determined the lists were useless. No evidence was presented that this was done in bad faith. Because movement has failed to meet his burden of proof, this court finds the claims of bad faith destruction of fingerprint evidence to be without merit. In addition, movement did not carry his burden to demonstrate bad faith destruction of whatever genetic material, if any, was present on the handle of the murder weapon prior to the knife handle being touched by Larner, Investigator McGee, and any other individuals. Um, and so, and that, I'm not going to go into all that. They just found that Larner's testimony was credible, and that because Movement failed to prove his claim by clear and convincing evidence, this court finds Movement's fifth claim to be without legal merit. And also in I'm not going to go through all this other stuff.
Yeah.
There's so much.
Yeah.
And it's kind of touching on similar, plowing similar grounds.
Right.
Um,
Facts
but
that have been already judged.
yeah, but he did find Movement's uh, he did find that a lot of the evidence about Asaro and Cole, the jury did hear it, so those claims are not
Yeah.
supported. And Movement's remaining evidence in support of Williams' freestanding innocence amounts to nothing more than old evidence, self-serving hearsay, and evidence the jury could never hear. The evidence presented fails under the standard enumerated in 547.031.3 and Omri. Movement has failed to demonstrate any basis for this court to find Williams actually innocent of first-degree murder. But the judge quoted the U.S. Supreme Court, and I think this is an important quote. So I want to include it because this is a fact that is often lost on a lot of true crime podcasters because they approach this from the defense side.
Right.
A defendant has been accused of a serious crime, and this is the time and place set for him to be tried by a jury of his peers and found either guilty or not guilty by that jury. To the greatest extent possible, all issues which bear on this charge should be determined in this proceeding. The accused is in the courtroom, the jury is in the box, the judge is on the bench, and the witnesses have been subpoenaed and duly sworn, await their turn to testify. Society's resources have been concentrated at that time and place in order to decide, within the limits of human fallibility, the question of guilt or innocence of one of its citizens. And that's from Wainwright versus Sykes, 433 U.S. 72. It's on page 90, and that decision was in 1977.
That is a
Um,
great quote. That is a
yeah,
great piece. And it's
because
basically,
it's,
yeah, it's saying a lot better than what I said. The general public read the headlines and still you could read a magazine article and decide that that Marcellus is innocent or Rodney Reed is innocent because of a long magazine article you read. But you know
yeah,
what? A lot of people worked really hard. They sweated. They spent nights and days and weeks putting together presentations, and a jury listened to them, and the end result was a verdict that can't be just fluffed off as racist jury members or
hmm
faulty, cops. That's I'm gonna actually try to cut and paste that and use that when I discuss cases like this because that's a really pithy way to talk about the importance of the jury process.
yeah. And that's when uh, a lot of the evidence and efforts are presented, and coming back years later and saying, well, the jury should have heard this or that. Well, not necessarily. I mean,
Mhm.
sometimes you're raising things the jury wouldn't have heard anyway.
Right.
But the judge finally closed with every claim of error Williams has asserted on direct appeal, post conviction review, and habeas review has been rejected by Missouri's courts. There is no basis for a court to find that Williams is innocent, and no court has made such a finding. Williams is guilty of first degree murder and has been sentenced to death. It is therefore ordered, a judge and decreed that movant's motion to vacate or set aside Williams' conviction and sentence is hereby denied. The prosecuting attorney filed a notice of appeal on September 16th, 2024. A notice of filing of hearing exhibits was filed on September 20th, 2024. The case went to the Supreme Court of Missouri. Um, and I'm not going to go through the cast of characters uh, with the prosecuting attorney. There was an issue of jurisdiction with the Supreme Court, which eventually accepted jurisdiction. Um, and the legal file and transcripts were entered on September 20th, 2024. On September 23rd, 2024, the Supreme Court of Missouri issued its opinion, and it said, despite nearly a quarter century of litigation in both state and federal courts, there is no credible evidence of actual innocence or any showing of constitutional error undermining confidence in the original judgment. Like every other court that reviewed every appeal and every habeas petition, the circuit court in this case correctly concluded that there is no basis for setting aside Marcellus Williams's conviction and sentence by proposed findings of fact and conclusions of law, abandoning the claim of actual innocence, and not appealing the circuit court's merits determination. The St. Louis prosecuting attorney irrefutably demonstrates what every other court has found, that there is no clear and convincing evidence that Marcellus Williams is actually innocent. And he, that's basically the circuit. They affirmed the circuit court's judgment, and the motion to stay execution was overruled as moot because Williams filed motion to stay execution. He tried a third 60B motion in federal court based on testimony from Larner that he presented as proving that the prosecutor excluded the jurors because they were black.
Yeah.
And the state filed a motion to dismiss. Williams filed a reply, and the court issued an order on September 19, 2024, saying Williams' motion seeks to relitigate my Batson decision. As noted above, I found that the Missouri Supreme Court's decision was supported by the record. This was a merits decision of Williams' claim. A Rule 60B motion is deemed to be a successive habeas petition if it attacks the federal court's previous resolution of a claim on the merits. Because Williams' motion seeks to revisit a claim that I have already denied on the merits, requires Williams to obtain an authorization from the United States Court of Appeals for the Eighth Circuit to proceed with this motion as a successive habeas petition, which he didn't do. Williams has failed to obtain this authorization, and his motion will be denied on this ground. The court also noted Williams asserts that Larner's statement wrong. That's one of the reasons. In response to the question, so you struck them because they were both young black men with glasses, shows that one of the reasons Gooden was struck was because he was black. That is a mischaracterization of Larner's testimony. Larner had just previously stated that Gooden and Williams looked very similar. The fact that they wore similar glasses was one reason for striking Gooden. Larner's testimony does not support Williams' inference that the fact that Gooden was black was one reason for striking him. As a result, Williams' motion for 60B6 relief regarding Larner's testimony is unsupported and will be denied. So the 60B motion was denied and dismissed. Williams appealed to the Eighth Circuit Court of Appeal. And that they filed all their pleadings in that under a very compressed timeline, because that was on September 19th, and on September 21st, the court issued an order dismissing the appeal and denying the application for certificate of appealability. And basically finding that it was not a Rule 60 motion, but it was a successive application, which is not allowed.
Yeah.
And that was, as you can see, Patrick, is a very long decision.
Yeah.
And I think I might have had a little issue because I think I might have had something cut off because I had it to not break across pages.
Oh, right.
I changed the font size, and then I missed a couple things. So he, of course, again, he filed writs at the U.S. Supreme Court, and those were denied on, he filed applications for motion, stays of execution at the U.S. Supreme Court, and those were denied. And I'm not going to go through all that. He submitted a petition for clemency. Those were all denied on, he filed two, one challenging the state court and one challenging the Eighth Circuit.
This is all the 21st of September.
Yeah.
All these things are going through.
The 21st, the 22nd, the 23rd. On the 24th, the Supreme Court denied both stays and both petitions.
Yeah.
And then he did file a petition for clemency. He filed a motion to stay execution in the state court. And again, during the week of the 20th. I mean, this shows what a compressed timeline.
Right.
The court again issued findings on, and I talked about this opinion earlier because this was in both actions. This was in the appeal of the motion to vacate and the motion to stay execution. So, and it basically found that, like the spoliation argument glosses over the necessity of showing intentional mishandling of evidence aimed at suppressing the truth, which they never did.
Right.
Um, and that they're misrepresenting Larner's testimony. Um, so again, it's a very long opinion.
Yeah. Boils down to,
They didn't prove their case.
yeah, struck
That's
out
the
again.
bottom line. They did not prove Williams was actually innocent. They didn't prove ineffective assistance. They didn't prove that Cole and Asaro were unreliable. They didn't prove, spoliation or a Youngblood violation.
A lot of
So
legal effort, a lot of legal effort involved with that, and I
yeah,
can imagine the hours and the time
yeah,
for somebody who I I, I don't want to dismiss the potential for innocence, but he was obviously not innocent.
no,
So yeah,
he was not. And a lot has been made about, Cole and Asaro. Cole did get part of the reward,
yeah,
but that doesn't mean, because
he did
again,
it
he
just for
went
the
to
reward. Yeah,
police after he got out of jail.
right.
Um, and, it's not like the minute Williams talked to him, he went to the jail and said, "Hey, what can you do for me?" And
Yeah.
while they're saying he was trying to avoid other charges, my research didn't show that he had anything else pending. He had been released from the workhouse.
Well, if
So,
you and it goes again, if you're going to offer a reward for the, you can't disparage someone for collecting the reward.
yeah.
Uh,
So on and he again challenged the state court's handling with the stay of execution and petition for writ of certiorari. Um, and those were again denied on the 24th. On the 24th, Governor Parson issued a press release that he said today, Governor Mike Parson confirmed that the state of Missouri will carry out the sentence of Marcellus Williams on Tuesday, September 24th, 2024, as ordered by the Supreme Court of Missouri. Marcellus Williams murdered Felicia Gale on August 11th, 1998. He burglarized Miss Gale's home, ambushed her as she left the shower, stabbed her 43 times, and left the knife lodged in her neck, and then stole items from her home. Williams was identified as the suspect after he was arrested for a string of robberies in the St. Louis area. Capital punishment cases are some of the hardest issues we have to address in the governor's office, but when it comes down to it, I follow the law and trust the integrity of our judicial system, Governor Parson said. Mr. Williams has exhausted due process in every judicial avenue, including over 15 hearings, attempting to argue his innocence and overturn his conviction. No jury nor court, including at trial, appellate, and Supreme Court levels, have ever found merit in Mr. Williams' innocence claims. At the end of the day, his guilty verdict and sentence of capital punishment were upheld. Nothing from the real facts of this case have led me to believe in Mr. Williams' innocence. As such, Mr. Williams' punishment will be carried out as ordered by the Supreme Court. I also want to add how deeply disturbed we've been about how this case has been covered. Mr. Williams' attorneys chose to muddy the waters about DNA evidence, claims of which courts have repeat, claims of which courts have repeatedly rejected. Yet some media outlets and activist groups have continued such claims without so much as a mention of the judicial proceedings or an unbiased analysis of the facts. I would just implore the media to do their due diligence and not rely on the sole claims of individuals who have a personal or monetary stake in this case. The facts are Mr. Williams has been found guilty, not by the governor's office, but by a jury of his peers and upheld by the courts, Governor Parsons continued. Williams has repeatedly alleged innocence despite overwhelming evidence to the contrary. None of the following fact finding entities have been convinced of his innocence. A jury of his peers at trial, the Missouri Supreme Court during state habeas proceedings, a board of inquiry, nor the St. Louis County Circuit Court. The state proved that Williams is guilty beyond a reasonable doubt due to a litany of factors listed below. DNA technology and testing before trial did not examine touch DNA based on standard techniques and practices at the time. Additionally, subsequent DNA testing has never exonerated Williams. Williams has a robust criminal history, including 15 felony convictions, in addition to offenses related to Miss Gale's murder, robbery, armed criminal action, assault, burglary, stealing a motor vehicle, and unlawful use of a weapon, which is all consistent with entering the home, attacking Miss Gale, and taking her items. So he has 2 robbery, 2 armed criminal actions, 2 assaults, 4 burglaries, 3 stealings under his belt.
Partridge in
Uh,
a pear tree.
Williams confessed the murder to his girlfriend soon after committing the horrific crime. Once his girlfriend found Miss Gale's purse in Williams's car, but he also threatened to kill her and her family if she told anyone, readily explaining why his girlfriend did not approach law enforcement until Williams was in custody. The girlfriend never requested the reward for information about Miss Gale's murder, despite claims that she was only interested in money. When speaking with law enforcement, the jailhouse informant provided information about the crime that was not publicly available, yet consistent with crime scene evidence and Williams' involvement. Other individuals were present when Williams bragged about this murder, and they were disclosed to Williams' team before trial and have been discussed in subsequent proceedings. These are guys who didn't want to testify, though.
Right.
So they denied any information or any knowledge. Gale's personal items were found in the trunk of Williams's car. Williams sold Miss Gale's husband's laptop to another individual who later identified Williams as a seller. Williams's disrespect for others' well-being and aversion to order have continued in prison, including attacking other inmates and threatening correctional officers. So, on September 24th, 2024, Williams, age 55, died via a lethal dose of pentobarbital. The execution was carried out just after 6 p.m. on September 24th, 2024, at the Eastern Reception Diagnostic and Correctional Center in Bonne Terre, Missouri. He was declared dead at 6:10 p.m. And
Justice served.
yeah, and to this day, if you search his name, you see all these articles that he was
Yeah.
executed despite evidence of his innocence.
Yeah. Racism.
Yeah, and racism,
Corrupt
and that was
courts.
and that was um that was there have been claims made about how there were 7 people in the veneer and only one African American was 7 African Americans in the veneer and only one was picked for the jury, but there were reasons other than race.
Yeah.
Probably. And he's only challenged 3. We don't know what the reasons were for the other 3.
Yeah, they bring up the same thing with Rodney Reed too, that there weren't enough
Yeah,
black people in the jury, but the percentage of black people in Bastrop itself was, I think, around 13 or 14%. So
correct.
that the few people that were on
And
there actually represented,
and
you
what
know.
I understand from David Fisher
Uh-oh.
is that not that I usually take what he says as a grain of salt, but from what I understand, David Fisher has made the comment that Reed was related to most of the African American people in Bastrop County
Right,
because his mother's family's from Bastrop County.
right, right.
So,
Well, this is very good. I really appreciate all the work that you put into this, and I
thank
think
you.
other people will too, considering how well documented this. And it is quite the hornet's nest of different appeals, and
Yeah.
then you have suddenly them trying to negate the government's appeal, and it was very confusing, but I think you did a great job putting it
Thank you.
together, and I appreciate you allowing me to tag along with you.
I appreciate you being able to fill in for Kyle.
Yeah.
He's like I said, he's celebrating graduations this weekend, and so
Well, it's the least I can do after you told me to bet on Napoleon Solo yesterday.
I didn't really.
No, you didn't.
I was really rooting for Great White
Yeah,
and
yeah,
Ocelli.
yeah,
And
yeah,
then I liked Taj Mahal because of the story with the trainer who would be the first female trainer to win the
right.
Preakness,
Which
and
would,
her
yeah,
husband, so first husband wife team,
yeah,
her husband is the jockey.
yeah.
But I wasn't even. And do you know where Napoleon Solo comes from?
Was it New Orleans?
No,
No.
it is actually from
Oh no! Oh, the
A
the
Man
name I
from
do know.
Uncle.
Yes, I did. Yeah, I saw the coverage for that, and yeah, the Man from Uncle, and
Which,
my wife liked the story behind Napoleon Solo too because he hangs out with a goat, right?
yeah. Um, Also, though, Napoleon Solo, I thought of this after the race was over. My cousin Melissa was in love with David McCallum,
Okay, he's the English
who
guy,
was
right?
the original, yeah, who was the original Man from Uncle. And so that would have been a bet that she would have placed.
Oh yes,
So
yes.
I should have caught it. If I'd caught it before, I would have sent it to you.
Well, I
Um,
appreciate because you got us to go out to our local casino here in New Hampshire, and we actually went to watched it with the crowd,
oh,
and
cool.
yeah, and nobody in the crowd was cheering for Napoleon Solo, so nobody nobody
So everybody
had
was disappointed. Yeah.
yeah, yeah, but
Well,
this is great.
I will try to do a better job with Belmont
Yeah, okay, let me know.
and give you, of course, to see who's gonna run
Yeah,
is always a question. And for those out there who are disappointed that Golden Tempo didn't, run in the Preakness,
yeah.
until Pimlico and Belmont reopen, any Triple Crown winner would have an asterisk next to their name
Oh, is that right?
because
So
I don't
Napoleon
think
Solo,
Belmont reopens until next year, and I don't know when Pimlico is going to reopen.
right,
So the Preakness Stakes is not really the Preakness Stakes because it's not being
right.
run at Pimlico.
Right, for the first time
And
in what, 120 years? 100,
yeah, and
yeah,
Belmont Stakes won't really be Belmont Stakes because if it's still at Saratoga,
right,
because it's not on Big Sandy.
right.
So once they reopen, then you can be disappointed. But I think racehorses are not as cut out now as they were for that timeline. And
Meaning,
you can't because it's no, it's 2 weeks between Kentucky Derby
oh,
and Preakness.
right, 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 right,
And
right,
then it's only 3 weeks between Preakness and Belmont.
right. That's tough on a horse.
And that is very tough on a horse.
Yeah,
On the horses today because they don't run as often as they used to.
right,
And how can you be mad at a trainer saying it's not a good idea for us to run him again after 2 weeks?
right,
We're doing what's best for the horse. How can anybody be upset with that?
right.
Of course, people are assigning ulterior motives, but the purses are still huge. It's
Yeah,
just the
yeah.
prestige is not going to be there for a Triple Crown winner
For right,
who runs at Laurel and then Saratoga
yeah.
because
The
it's not the same.
Great White was scratched, right, from Kentucky Derby.
From the Kentucky Derby, yes.
Yeah,
And I heard actually, I said if he can keep his crap together, but I heard that he actually had a problem with the bit.
I think we did see him kind of go off when the other
Yeah.
ones were lining up. Great
And
White kind of like,
he
yeah,
was like, and he also, I think he doesn't like to stand still.
right, yeah,
And so when he was standing next to the pony, he didn't like that. And either in trying to, rein him in, the bit aggravated him or
Hmm.
hurt him. I'm not sure. And so that was why he reared up, but he's 1,350 pounds.
Yeah.
What goes up must come down.
A lot of
And
horse
sometimes the momentum of rear means you're not going to go front, you're going to go back.
to the side. Yeah. Yeah.
And that was what he did. Thankfully, he didn't fall on the jockey. But I
Yeah.
think the jockey like saw, oh, this is not going to end well, because he kind of launched himself off.
Yeah. Yeah.
So he has excellent reflexes.
For saving
But
his
they
own
ran a good
life. Yeah.
race.
Yeah.
And
Very good, Lisa. Well, again, thank you for having me on,
thank
and
you for coming.
I look forward to hearing more about this in the future. And thank Kyle for me. And
I
have
sure
a great
will.
Sunday, great week.
And I hope we can do this again.
Absolutely. Let me know.
All right. Thank you, Patrick.
Thank you. Bye bye.
Bye. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and guest co-host Patrick. If you'd like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 3 weeks for episode 8, State of Texas versus James Garfield Broadnax. In
That was painful.
2008, Broadnax and his
Yeah.
cousin
Yeah.
Demarius
That was
Cummings
It was brutal
robbed and
stuff.
killed Stephen Swan.
What?
Pardon me. Robbed and killed Stephen Swan and Matthew Butler in the parking lot of Butler's recording studio in Garland, Texas. Shortly after his arrest, Broadnax confessed to shooting and killing Stephen and Matthew. We'll talk about the case against Broadnax, his trial, direct appeal, and state and federal claims, and the false claims made by Cummings ahead of Broadnax's recent execution. Until then, have a great 3 weeks and stay safe.